YouTube. I'm going to attempt to do a shorter video called Prop 8 The History. And today I am going to basically try to bring you up to speed with the Proposition 8 trial and where it's at right now. Right now it is currently being appealed to the Supreme Court. The Supreme Court will grant certiorari or deny certiorari, and that's simply we will hear it. We will certify it to be heard. But it goes back to 2000. But it goes a little bit further than that with 1996. In 1996, DOMA was passed because of Hawaii, and they were saying that it sex discrimination is heightened scrutiny, and since this is discrimination based on gender, then you have to satisfy it, and it does come under the Equal Protection Clause of the United States Constitution. Washington panicked and passed DOMA. Hawaii later panicked and passed a ballot measure that gave the legislature the express ability to limit marriage to a heterosexual union in the law. Now, 4 years after DOMA is signed, the statute passed called the Knight Initiative, Proposition 22, passes with 62% of the vote, and it becomes law. In 2004, Gavin Newsom inserted himself into the debate over marriage by granting same-gender couples a marriage license. And this is chronicled in The Pursuit of Equality. You should definitely get that, because it's awesome. And you know what? I love Gavin Newsom's hair in that. And people said that he would never become governor or lieutenant governor ever, along with Jerry Brown, and now they are governor and lieutenant governor. I find that very funny. But he inserted himself in this debate because of the simple fact that when he went to Washington, all Bush talked about was protecting marriage and keeping marriage between a man and a woman, and called on a federal amendment to the state constitution. Called for the states to ratify an amendment to the federal constitution expressly forbidding the recognition of marriage between gay and lesbian couples ever. So, gets these licenses. The court order says no, they're invalid. Purge the system of those records. Then they sue. Okay. Intermediate court or a lower court, this does violate the Constitution. Appeals court, this does not violate the Constitution. We uphold it. In remarriages cases, in 2008, 16 different cases, they swooped them all in and heard en banc, which is simply all of them together. The California Supreme Court hears all cases that way, and there are 7 of them. They heard the cases for the remarriages, and they said that the marriage statute called Proposition 22, passed with 62% of the vote, does violate the state constitution. And I believe in February of that year, they did make a determination that sexual orientation does not play a part in the rearing of children. So, where is this going? While Proposition 22 was being challenged sneakily and quietly, the Mormon Church, along with some California groups, decided that they were going to preempt a favorable ruling by the court. In May of 2008, that favorable ruling came down, I believe, shortly before Proposition 8, or before Proposition 22 was struck down. Proposition 8 qualified for the ballot. And on November 4th, 2008, voters passed with 52% of the vote Proposition 8. Proposition 8 passed with 20 less points of support than Proposition 22 did 8 years before. And Proposition No on 8 raised $36 million, Yes on 8, $32. And in order for a ballot measure to succeed in California, you need money. So, where does this go next? In January of 2010, or actually in 2009, they had to file the paperwork and get ready for the January 2010 trial in Judge Vaughn Walker's courtroom. He was the chief judge of the Northern California District. 13 grueling days of testimony, closing arguments, and then August 4th, 2010, Proposition 8 was struck down as unconstitutional, violating due process and equal protection. Then it went to the Ninth Circuit Court in December of that year, and they had to qualify, they had to send an advisory opinion to the California Supreme Court saying, hey, does California law, is there a precedent for California to give the backers of a ballot initiative the ability to argue that in court? Within about 3 months, the California Supreme Court in November of 2011 said, yes, they do, because to not do so would in fact give the governor a pocket veto, and the governor cannot, according to our Constitution, give a pocket veto for a ballot measure that they will not defend and because they do not like it. February of 2012, victory in the Ninth Circuit. Then, I believe later on, maybe in June of 2012, led by Chief Judge Alex Kaczynski of the Ninth Circuit, him and I believe an 11-judge panel overwhelmingly rejected, with four judges dissenting, a rehearing of the case. Simply, they stated that it was not necessary for them to hear the case, as the case had been rightly decided. The backers of Proposition 8 had also been doing a lot of other sneaky things, such as trying to get the ruling vacated, trying to take video, to deny us access to the video, which I believe we should have access to the video. The Ninth Circuit Court said, no, you shall not have access. And even though I disrespectfully agree, because of the fact that I want to hear exactly what they said in their voices, in their words. Although the transcripts survive and we do have the play, but I would want to see the actual people, the actual things. And I believe that the video was blurred or something like that, so that you couldn't tell who it was or whatever. But that was for his personal record, but it was put in the public record, so I believe that those tapes should be unsealed. However, those were one of the many stall tactics that the proponents of Proposition 8 tried to get through in order for the ballot measure to be. They were trying to get a favorable ruling for them. However, now it is in the hands of the Supreme Court, and now they can either deny or grant a hearing of the case, and it only takes 4 to say that they will hear it. I'm sure Thomas and Scalia will definitely be 2 of those, and maybe Alito and Roberts. So I think that they may very well take the case. However, since it's on the narrow grounds of taking away a new right because it is new, or newly recognized rather, that may very well stop the Supreme Court short, because I do believe that they have done this with the Romer versus Evans case with Amendment 2. And if you look at the Romer versus Evans case, this is very similar. Romer was about 3 municipalities enacting a non-discrimination ordinance, which the state of Colorado popularly passed an amendment to their constitution saying that no political body can intervene to make sexual orientation a protected status. And it was the first of its kind, and in order to amend the state, in order to get relief, they had to amend the state constitution and basically ask the electorate if it was okay for them. So that's basically what the voters of California would end up basically having to do in order to grant same-gender couples the right or the ability to designate the term marriage for their unions. So this is a shorter history of Proposition 8. I hope that you are tuned in. Recently, the case was closed, but again on appeal by the Supreme Court, so we'll see what they do. Have a great day, YouTube, and I'll see you later.